From WKNOW, this is Steve Chanley with One Question Too Many. Today's program is made possible by the law firm of Employer Advocates Group, serving California employers since 2002, with offices in Orange County and San Luis Obispo County, California. eaglawgroup.com. Joining us today is Becky James, a former assistant U.S. attorney for the Central District of California, who is currently of counsel with Employer Advocates Group. She spent more than 12 years as a federal prosecutor and served as chief of the Criminal Appeals Section and chief and deputy chief of the General Crimes Section. In that role, she oversaw approximately 500 appeals per year for the Criminal Division. Thanks for being with us, Becky.
Sure, Steve. Happy to be here.
How long have you been practicing law?
I've been practicing law for over 30 years.
Always have to ask that.
I actually can't believe it's been that long.
So right after graduating from Stanford Law School, you did a federal clerkship. Can you tell us about that?
Sure. It was a great experience. I clerked for Judge Pamela Reimer on the Ninth Circuit. Really one of the best experiences of my professional life. She was just a tremendous judge and tremendous person to work with, and the clerkship experience itself was so valuable and so interesting. Just something to do right after graduating from law school is it's just such a thrill to be deciding such important cases, and not deciding them but helping the judge decide them. And going, it was never a dull day. It was always really interesting work.
What are some of the enduring lessons that you learned from your clerkship?
I think one of the things is the importance of clarity in your writing. It was so difficult to get through those briefs when they were not well written and not clear, because the clerk's job is just to try and make sense of it all, and it's so much harder if it's not clear from the briefs. So making it easy for the clerks is really important. The importance of preserving the record for appeal, because we would find waiver anytime we could. If there was a possibility of getting rid of an issue simply and easily by saying, oh, it wasn't raised in the lower court, we would do it. So, the importance of preserving that record. And I guess the last thing I would say is, another lesson was that most people are just pathetically bad at oral argument. The oral arguments were notoriously unhelpful. And it gave me comfort later in my career that, knowing that most people aren't actually that skilled at it. Even very experienced lawyers often do not really do that great a job. So it lowers the stress level a little bit when you realize that.
Immediately after your clerkship, you began private practice at one of the big law firms. And I mean that in the big law run-together sense in Los Angeles. What was the nature of your practice at that time?
Yeah, I was a civil litigation associate. Did mostly commercial litigation. I was at Melbourne and Myers, and it was definitely big law. We had big cases, and I was usually kind of a small player in a big case. But I got pretty lucky actually there, and had some cases. They were big cases, but they had sometimes smaller components that I was able to get some pretty good experience handling some things on my own, doing some arbitrations and depositions and things, motions practice and that sort of thing on my own. So I got pretty lucky with my experience. And I had a trial when I was there too that I was part of, albeit, more backroom help than courtroom help. But it was still a very interesting case and some interesting work.
Did you find that it was a meaningful experience just to pull together what needed to be prepared for a presentation?
I worked on one aspect of the case because it was a huge technology case, and I focused primarily on one aspect, and then just a couple of witnesses in that aspect. But prepping the witness was, a lot of what I did, and reviewing the documents and everything that went along with that. So, but getting up to speed and learning that issue. So I did a lot of legal briefing on that too, which I enjoyed doing because that's my thing. But it was very valuable to be part of it and see what goes into a trial, even if, I wasn't in the courtroom as much as I would have liked.
In 1994, you took a position in the U.S. Attorney's Office in Los Angeles as an associate U.S. attorney. How difficult was it to transition from private practice into public practice and from civil law to criminal law?
Well, it was a steep learning curve, to be sure. It was, really, although I got some pretty good experience at O'Melveny, it was still nothing like being at the U.S. Attorney's Office where, you're really handling your own cases and from the get-go. And then of course, just learning criminal law. I had done just a very small amount of criminal practice at O'Melveny, but, very little compared to what, of course, then like practice became exclusively criminal law at the U.S. Attorney's Office. And I had to learn all of that. So it was definitely, like I said, a steep learning curve. Otherwise, I enjoyed the transition. I really liked the criminal law aspect, and so it wasn't a difficult transition. It wasn't a bad transition, I guess I should say. It was a challenging one, but not a bad one.
What were some of those challenges initially?
I would say the biggest challenge was handling cases on my own. I was the lead prosecutor on most of my cases from the beginning. So in the U.S. Attorney's Office, in our U.S. Attorney's Office and most U.S. Attorney's offices, I'd say you're really kind of thrown into cases right off the bat. I had my first trial my 6th week in the office, so it was definitely a challenge to kind of get up to speed and know what to do. We had mentors though. I had a mentor, a more senior lawyer who worked with me, and we had supervisors, of course, but still it all kind of came down to me. I mean, I'm the one who tried the case. I'm the one who did everything on my cases. So just with guidance and input, but it wasn't like I was working for a partner and somebody else was in charge of, this is you. So that was probably the biggest challenge, but that's that's how you learn too. You just have to learn by doing. And so that's what we did.
Can you tell our listeners what an assistant U.S. attorney does?
Yeah, so we prosecute all federal cases. So federal cases are ones that involve the federal statutes. Usually there's some interstate connection, or there's certain topic areas like drugs, for example, that just are tried or charged or can be charged either state or federally, but there's federal jurisdiction. And there's other ones that are like major frauds that involve the mails or the wires, things that confer federal jurisdiction. Immigration is another one. Bank robberies, interestingly, go federally because of the FDIC insurance. And so certain, there's terrorism-related offenses, which I got into later. But yeah, the first year in the U.S. Attorney's Office, you're put on a rookie row, as I started just described, is about, really just getting in there and learning how to try cases. So they would be small cases, but you handle them on your own, and you hopefully go to trial and learn that way, on real cases. And then after that, you graduate into a more senior section. In my case, I went into the appeals section, but I also split my time with another substantive section. So I was in what was then called the major crime section. Didn't exist that way after a while, but it was our violent crimes and miscellaneous crimes section. So I kind of split my time between doing trial work and doing appellate work, but I did focus a lot of my energy throughout my time there on appeals.
So a U.S. attorney's practice can include both civil and criminal cases?
Not in our district. In our district, there are different divisions, and I think most places that's the case, unless it's a very small district. But yeah, no, we have a criminal division and a civil division, and so there were some AUSAs who do civil cases, and they represent the government in civil actions. Tort claims against the government, for example, go to the civil AUSAs, but the criminal crimes, the prosecutions that I was talking about are all handled. So you're in one or the other, and I was in the criminal division.
Can you explain to our listeners how criminal procedure ties in with constitutional law?
Sure. Most criminal procedure emanates from the Constitution. And so the Fourth Amendment, the Fifth Amendment, the Sixth Amendment, one thing you become very familiar with in practicing criminal law is that, your Bill of Rights. So we know all those amendments very well. So there are other rules. The federal rules of criminal procedure do add to that and provide some greater protections. For example, a little bit broader discovery rights under the federal rules than there are strictly under the Constitution. But most of the basics of criminal procedure, like search and seizure law and jury trial rights, confrontation clause, all those things come from the Constitution. So they're the right to counsel. These are things that are protected very seriously. They come from the Constitution. These are not rights that can be violated easily or should be violated easily.
How about right, the procedural right to due process?
Yeah, it's so important in criminal procedure. Just try to imagine yourself being falsely accused of a crime, and you'd need all those protections of a fair system to be assured that you can get a fair trial and you don't get falsely convicted. And it's no joke. There are people who are falsely accused. There are people who maybe shouldn't be are there who shouldn't be there. But everyone, no matter what the circumstances, deserves a fair trial. There's not something that we should ever take for granted, because while there's a presumption of innocence in the case law coming from the Constitution, there is not really. In reality, there's a presumption of guilt. And I think that most people do believe, and the media kind of fosters this, and we all just kind of chuckle and think, oh yeah, the guy was arrested, of course he's guilty, right? So there's a real presumption that you, as a defense lawyer, you have to get over. It benefits you when you're the prosecutor. But you have to really jealously guard that presumption of innocence and really fight for it, because it's such a cornerstone of our criminal process. But it's one that is so easily violated. But we can't convict people on the basis of a presumption or just an assumption that they're guilty. We really need to be convicting people on proof beyond a reasonable doubt.
At some point, your practice became focused on criminal appeals. How did that come about?
Well, I was always interested in going into appeals, and so I was actually slated for the appeals section when I started at the U.S. Attorney's Office, and I just started developing that interest when I was at Melviny, and that was, in part, I kind of alluded to it before, that I really liked the legal issues and doing briefing and addressing the legal questions that came up in cases. So I didn't really do a lot of appellate work. I did some appellate work at Melviny, but not really a ton. But I knew that was what I was interested in doing. So when I went to the U.S. Attorney's Office, it was actually to go and be an appellate lawyer there, and there was an opening in the appellate section. They were pretty new at that time. It was just the chief and one other lawyer. The other lawyer happened to be someone I knew. So he knew that they were hiring and looking to expand their appellate section. So he was the one who told me about the position and kind of encouraged me to apply. So it was always known from the beginning that I was going to go there. The way it came about that I ended up splitting my time, most of us in the appeals section did end up splitting our time. And there was a thought, and I had to go through Rookie Row like everyone else. I had to, learn to try cases, because there was a real thought that, you can't be a good appellate lawyer without knowing how to try a case. Because if you don't know the procedures and you don't know, frankly, what it's like to be a trial lawyer, you can't have a real appreciation for all the process and appreciation for the trial lawyers who do the work. So they really want us to have that training and that background in doing appeals, and actually to keep it up. Most of us wanted to sort of do both, because it just kept life kind of interesting too, to do some trial work as well as some appellate work. So most of us did split our time in that way.
You were appointed into positions of leadership at the U.S. Attorney's Office. Can you explain to our listeners what you did in those positions and how that was different from the work that you did before?
Yes. I started out, I got promoted to the Deputy Chief of General Crimes and later to the Chief position. And then after that, I became the Chief of Appeals. I would have to say that being the Deputy Chief of General Crimes was a real kick. It was really fun. The General Crimes section is the rookie section. It's the section that the new attorneys come into, and during that first year or so of their practice. And it's when they're learning how to try cases and taking those small matters and running with them through plea or trial and sentencing and appeals and everything else that comes along. And so my position in being the deputy chief was all about training those people and all about mentoring them and teaching them how to do the work. And that was just great fun. It was really fun taking these, and working with them and helping them strategize about their cases, seeing them grow into qualified prosecutors. So that was great fun. I then became the chief of general crimes, which was a little more administrative and a little more managerial. So I would say a little less fun, actually. It got a little bit more removed from the actual trial work and more into the management aspects of the job, but still very rewarding too. And then I became a chief of appeals, and our appellate section, this is not true everywhere, but in our office, the trial AUSAs presumptively handle their own appeals. They do the primary writing on the appeals, and they do usually handle the oral arguments. But the appellate section was there to edit, do moot courts, to assist. So we did pretty heavy editing, but we would typically be editors. Now there were some times when we didn't. We would become the primary writers because AUSA had left the office, or for some reason couldn't handle their own appeal, or if it was a government appeal, we would handle our own. So in the chief position, I supervised the people in the appellate section who were supervising. I supervised the supervisors, kind of. The appeal sections that you mentioned earlier on, there were over 500 criminal appeals a year, so it was a huge job. Just to sort of manage all of those appeals that we were handling. That was a lot of it. And one of the really interesting parts of that job, being the chief of appeals, was I had to be involved in any adverse decisions that came against us. So if there were adverse that were appealable, so if there were adverse decisions, an adverse decision on a motion to suppress, for example, is appealable. An acquittal is not, actually, because if there's an acquittal at trial, government cannot appeal it. It's double jeopardy. You can't appeal. So it wasn't acquittals, but it was legal losses, like on motion, like I said, motions to suppress. Sometimes there might be a motion to dismiss, or there might be sentencing appeals too. There could be sentences that were maybe excessively light in our view that could be appealed. So in those situations, we would, or we might lose a case on appeal. That's the other place that an adverse decision could happen, on appeal itself. And so in those situations, we'd have to go to the Solicitor General's office ultimately to have them make a decision. Our recommendation, we would make a recommendation as to whether to appeal or to seek further review through en banc or cert petition in the cases that we lost. And so there was a lot of interaction with the Solicitor General's office and Main Justice as well, the appellate section of the Criminal Division of the Department of Justice, in analyzing those cases for appeal. And that was a very interesting part of the job that I wasn't very involved in before I became the chief, but as the chief of appeals, that was a big part of it.
You had mentioned before about mentoring younger attorneys. You also had significant experience training and teaching attorneys trial advocacy and appellate advocacy skills as part of the DOJ's National Advocacy Center. Is that right?
Yes.
Can you tell us a little bit about that?
Yeah, so DOJ has a National Advocacy Center, so they send everybody off for training. That was one of the things that we did. I don't think I ever went to the trial which was kind of unusual, but I did appellate advocacy, the appellate advocacy training when I was a new attorney. But I also then, when I became a more senior attorney, then I taught at the National Advocacy Center. I taught trial ad and appellate ad. That was a lot of fun too, just being able to teach, because it's usually the newer people, although with appellate advocacy, sometimes you have more senior people coming in for training on that because it wasn't necessarily something that most people did every day. But the trial advocacy, usually we had people again usually in their first year, coming in and getting trained. So they would come from around the country, and we would all travel to South Carolina to do these trainings. So I also taught as an adjunct professor at Loyola Law School and Pepperdine Law School. I taught appellate advocacy at Loyola, and I taught white collar crime at Pepperdine.
In addition to formal classroom type learning, how important to an attorney's development is more informal types of mentoring?
Mentorship was so important. I think that the U.S. Attorney's Office, we appointed mentors who could help people, and just having someone to ask questions is really important. You don't always want to go to a supervisor, in those situations, though certainly people came to me too when I was a supervisor, but having just a senior person who could kind of show you the ropes was hugely important. I think in a career sense, that's really important too. Always having someone you can bounce ideas off of, and someone you can give you some ideas about career trajectory and where to go, what you might want to do with your career. It never ends. I mean, I think there's always those people who are valuable to us and who can give us direction.
So, with the State Bar of California, you're certified as an appellate specialist. Is that correct?
Yes, I am. Yeah.
If you had to list the top three things that every appellate attorney should know about brief writing, what would those be?
Organization, organization, organization. Um, as I mentioned, before, being a clerk, the most important thing is to be clear. You can't be clear unless your brief is really well organized. But if it's really well organized, and you should be able to read it, read the table of contents and get a good idea of the nature of the argument, what the argument is, just from looking at those headings, because the headings should tell you what the arguments are and kind of the order they're going to be made. And I've edited hundreds of briefs because that's what I did at the U.S. Attorney's Office, and since then. And it's just the one thing that I'm just a real stickler about is organization and making sure that it follows logically, and you can lead the reader by the hand through your argument, and they can follow along and say, okay, I see where we get from point A to point B. It's not easy. It takes time, and you have to write and rewrite sometimes. But I really recommend outlining before you start writing, and really giving thought, like I said, to those headings about what they're gonna, how it's gonna read and how it's gonna look. That's what I would say.
You mentioned earlier during your clerkship at the Ninth Circuit that you had the distinct misfortune to witness a lot of very bad oral argument. What would you say are the top three things that appellate attorneys should know about oral argument?
Well, the good news is it just doesn't matter very much. Most of the cases are about 90% decided, if not more, on the briefs. So in the federal system, they aren't technically decided before that, but the judges all read them before the oral argument, have a bench memo already prepared before the oral argument, and have a pretty good idea of where they're going with the decision before the oral argument happens. In California State Court, it's even more. It's even more than that. They usually have a tentative decision drafted before they even go into oral argument. So it's thankfully a pretty small part of the practice. And I say thankfully because oral argument's just really hard. It's just really hard. You got to be prepared for everything and anything, and it's you're on the spot. It's nerve-wracking. So it's a very challenging thing to do. It can be really fun too. It can be really rewarding. To get into an intellectual exchange with these judges, it's really interesting, but it's not easy. And I think some of the tips for oral argument to make it a little more effective and a little less bad is to really answer the judges' questions. I mean, they're there. A lot of people want to stick to their script, so heavily, but it's really much more important to stop and listen to the judge's questions and answer those questions thoroughly, and then we can move back into your argument, but make sure you answer the judge's questions and answer them directly. I think, a lot of times we lawyers we're so verbose that we forget to say yes or no, and we just kind of launch into some long explanation that may not really answer the question, but you really got to answer the question. And judges will get frustrated with you if you don't. So I think that's a really important thing too. And again, organization is really important. Sort of giving a roadmap at the beginning of how you're going to organize your argument. But in the case of oral argument, that has to, fall to answering the judge's questions. So if you have to give up your organization and your script to answer the flow of the judge's questions, then you give that. That's more important than following the order that you were planning to go in.
How do you prepare for oral argument?
Oh gosh, it's a long process. I gather or have somebody help me gather all the materials that I'll need in one place. So that's the briefs, the excerpts of record, the appendix, and all the cases and statutes that I need. And I usually just put those in alphabetical order. I usually just create a digital folder or set of folders with all those materials set up. So then it's all in one place, and I just go there to look at everything. I usually reread the record, as much of the record as is relevant to the appeal. And sometimes that means rereading the trial record, because you just got to know that record really well. I guess I should have said that in the last question. Knowing your record really well is very important for oral argument. That's often where the judges need the most help, is just because they may not have read that whole record, or they haven't read it very closely, don't know it as well as you do. So it's really important to have that record down cold, focus in on the cases that are the most relevant. But anything that's cited in your brief is fair game, and sometimes things that aren't cited in your brief. So it's important to know the cases well too. And so I usually read those and take some little notes about, so I can remind myself what each case is about, and then pull out, if there's anything I want to pull out from the cases, some language, I'll have that, maybe ready to go in my outline or tabbed or whatever. Same thing with the record. If there's things you want to pull out from the record, you tab those, you highlight them, and maybe just draw them into your outline, so you're ready to get some good quotes or give some page numbers and that sort of thing. Judges love it when you can give page numbers from your record, so that's helpful.
Or sometimes engage in moot oral argument with another person?
Oh, yeah. Moots are great. I do a lot of moot courting myself. Not a lot, but I am fairly often called upon to be a moot court judge for people. And then I used to always we would always do moot courts at the U.S. Attorney's Office. That was something that we did in the appellate section. We would moot pretty much every argument before. And people who don't know what a moot court is, it's just basically a practice run, right? It's moot because it's not real, and so it's a mock argument. And you have somebody play the judges. You usually get a panel of 3, because appeals are usually heard by panels of 3, and you get 3 people up there to pretend to be judges and ask judges questions that the real judges may ask you during oral argument. So you get practice both giving your argument but really answering the judges' questions. So moots are really, really helpful. I try to do them now, but I've probably gotten to the point of doing them a little bit less, just because of practical reasons. Really, there's just not always the budget to do that. But if there is the budget, it's probably the single most helpful thing you can do to prepare for oral argument.
Are there any oral arguments that really stand out to you that you've done in the past?
I don't know if there's any oral arguments that I have had that have really stood out, but I will tell you one of my great idols in the law, Paul Clement. We may disagree politically, but we don't. But he is really an amazing oral advocate. And I worked with him. He was at the Solicitor General's office. He was actually Principal Deputy Solicitor General at the time. He later became Solicitor General. So when I was Chief of Appeals, I was working with the Solicitor General's office. Actually, before I was even chief, I worked with Paul, and we worked, and it was a really kind of an unpleasant assignment. This was back in the Bush administration following 9/11, and we were housing suspected terrorists at Guantanamo Bay. And there was a habeas petition brought on the behalf of these detainees. And this became something that it came to our office just by sort of the happenstance of who filed it, the petition. And so our office handled these initially, but pretty quickly the Solicitor General's office got involved. And so I worked with Paul Clement on those cases, and he was just such an amazing advocate. He could get up there, and I was just telling some folks about this. He would get up there with no notes, not an outline, nothing, just blank lectern on him. And it was really something to see, because he was so skilled at it. But it's smart, because really the reality is, know your record so well, and we all tend to get really tied to our little notebook and our note and our outline, and that we can have our head down and our notes, and we aren't really engaging with the judges. But he had such an effective manner of engaging with the judges, and he could just rattle off what he needed to rattle off from memory, because of course after you've done all the prep, you've got it committed to memory. So you just have to trust, I think, that you have it committed to memory. Those were not easy arguments either that he handled. There were quite a bit of resistance to the administration's policy at that time. So we got some challenging questions, but really it was really quite something to see.
After about 13 years of public service at the U.S. Attorney's Office, you returned to private practice. What was the nature of your practice immediately after you left the U.S. Attorney's Office?
Well, I went back into private practice. I went to Manat, Phelps & Phillips first off out of the U.S. Attorney's Office. I later opened my own practice, but basically my practice areas ever since then have included appeals and white collar criminal defense, which is basically what I learned at the U.S. Attorney's Office, criminal defense in general, federal criminal defense. But, I have an emphasis on white collar cases and then appeals. And so I do at Manat, I was one of the co-chairs of the National Appellate Practice and a member of the white collar group. And I did both. And then when I opened my own shop, I continued those practice areas.
Was it a difficult transition for you to go from being a prosecutor to being a criminal defense attorney?
It really wasn't. I had always actually kind of wanted to be a criminal defense lawyer, even from the time I was in law school. I think I thought I had more of a criminal defense bent. So sort of funny that I ended up spending over 12 years as a prosecutor, but I never thought I would spend that long. I didn't really think I would go to the prosecutor's office in the first place. But I got there because of the way things happened. The public defender's office was not hiring. They had not yet started their appellate section. I was interested in doing appellate work. They were thinking about it, they hadn't yet started it, so they weren't in a position to hire me, but the U.S. Attorney's Office was. So I ended up going to the U.S. Attorney's Office, and I was persuaded to go there because a Ninth Circuit judge gave a talk about it and he had been a U.S. attorney before, and he talked about the importance of having people who care about due process and who care about the rights of the criminal defendants, how important it is to have those people in the position of prosecutors, because prosecutors have so much power and so much discretion that you don't want the entire prosecutor's office to be made up of, people who don't care about those things. You need to have people who have the conscience and, who really, really want to do the right thing. So he persuaded me that it, made sense to be a prosecutor. So I always had that love of the process and everything in my practice. So when I transitioned from being a prosecutor to being a defense lawyer, it was actually pretty natural, and I just actually felt more in my element as a defense lawyer than I ever really did as a prosecutor.
For a period of time, you also worked as a public defender at the state level. Can you tell us a little bit about that experience?
Yeah, well, this was kind of a little foray I did. So a few years back, I moved to Texas, and we live outside of San Antonio in a rural county. This rural county, as well as the other counties around San Antonio, did not have a public defender's office. And they were struggling with getting good defense lawyers and having the criminal defendants in these areas be adequately represented. So they didn't have a public defender's office. So this opportunity came up. They decided, these 4 counties got together because they're tiny counties, so that any one of them could not have supported a public defender's office on their own. So 4 counties got together and decided they would co-fund a public defender's office. So they were looking for a chief. I actually left private practice for a bit and went and opened up that office. It was a really interesting thing to do and a really rewarding thing to do because it was so valuable. It's hard to imagine coming to California where there are public defenders everywhere, but in Texas, lots of places don't have them. And it's a relatively new thing to have these, dedicated public defenders offices, but it really helps in providing a cohesive and adequate supply of criminal defense for the criminal defense who come through those doors. So it was a very interesting project. I had to start it from the ground up. I had nothing when I started. We had 2 lawyers who came over. Actually, since we had nothing, we had 2 lawyers who came over from the prior sort of effort they had made. It was a nonprofit group, and they came over, and we started with them, and then we expanded to about 11 lawyers by the time I left. So it was a lot of hiring, a lot of training. We brought in people straight out of law school because pay is pretty low. So people who were really interested in the job were typically pretty new lawyers, but we trained them and got them up and running. I kind of drew on my experience from the U.S. Attorney's Office of 200 people in there. Teaching them on the go, but try to provide a lot of support to the lawyers and through training and education and supervision, and we were able to get the project going. It's still going today. I left after about 1.5 years. I kind of needed to get back to private practice for some personal reasons, but they continue to this day. and there's been very successful. So there were definitely some naysayers out in our rural counties. There were folks who didn't think we needed a public defender's office. There were some folks in positions of power even who thought we didn't really need this public defender's office, and why do we have to spend money on it? But we brought them around, and after we got some people doing really good work out there, they saw the value, and so now they have it. I think it's there to stay.
Can you tell us about some of the pro bono work you've done?
Yeah, probably the most interesting pro bono case I've had, at least relatively recently, was I represented a rape victim whose test kit was not tested. And it turns out this is an incredibly common occurrence. There are huge backlogs of rape test kits that are not analyzed. And this is the evidence, right? This is the laboratory evidence that they collect. Painstakingly collect the evidence after a rape allegation, but then the police labs do not process them, and we found that they were sitting there for years at a time, not being processed. And this happened in San Francisco, but it's happening all over the United States. So this became a real cause for my client, and she actually just became an advocate for rape victims and an advocate on this issue, because it's a really discriminatory practice of, not taking this particular crime seriously. So the excuse is, well, we have so many other things we have to do. But the reality is they're just not taking that crime seriously. And so a sexual assault allegation disproportionately affects women, and they were just, systematically deprioritizing that particular offense. My client had brought a federal lawsuit alleging the discriminatory enforcement practice, and her case was thrown out in the district court and went up to the Ninth Circuit and was affirmed. And so we did a cert petition, which is a petition to the United States Supreme Court, where that's when I came into the case, and we did a Supreme Court petition. It was ultimately denied, which the vast majority of them are. They didn't hear the case. But we got some real press out of this case, and got some attention, a spotlight focused on the issue. Hopefully some changes have occurred as a result. I know some changes did occur as a result of the lawsuit and the cert petition and the press that came of it. So that was a very interesting one. I also, earlier on in my career, did some clemency petitions for women who had been abused usually by their husbands or by their partners, had protected themselves by actually killing their abusers. So we would not argue that they weren't guilty of crime, but we argued that there should be leniency in their sentencing because of the extenuating circumstances. And so that was a project I worked on earlier on. There have been some others too, but those are probably some of the more interesting things I've done.
Were you able to achieve the clemency that you were seeking in some of those cases?
I did not. And the time I was there, they were still pending, actually, at the time. Because then I went, that was when I was an associate in Albany, and then I went to the U.S. Attorney's Office. And so I had to give those cases up. But they were ultimately handed off to to one of the post-conviction justice projects. And I don't know whether they ended up, how they came out or not.
Do you believe that attorneys have a social duty to serve the public in some way?
Well, I think that all attorneys serve the public in some way. Some it's harder to feel that way about than others, but I think we all serve the public. And I think that everyone who plays a role in our justice system serves that system and serves the public in that way. I happen to really enjoy public service in the sense of I'm working for the government or, working for the public defender's office and doing court-appointed cases too. I've been a court-appointed lawyer. I haven't really enjoyed that, but I think even if you're a private lawyer, you're serving the public. And it's sort of the same way that I think whether you're a prosecutor or a defense lawyer, everyone's role is important. And everyone's role is equally important because, you got to have good advocates on both sides of the issue for the system to work. So whatever it is that lawyers are doing, I think is really in the public service.
This may seem as a real non sequitur, but it really isn't. Have you ever asked that one question too many?
Fortunately, I couldn't really come up with an example of a time that I have done that. But I definitely can talk about a time when my opposing counsel did it. Yeah, so I was at the U.S. Attorney's Office, and I was representing the government against a case who had um, a defendant who had threatened this woman. It was an ex-girlfriend situation, and he was threatening her over the phone lines and through the mail, so it became this federal offense, and it was really bad threats. And he pled guilty to the offense, and so one of the elements of the offense of making threats is that you intend to threaten physical harm. Not that you actually have to intend to carry out the threat, but that you intend to threaten physical harm. Okay, so he pled guilty, and then we had a contested sentencing hearing. He brought in an expert witness to testify in his sentencing, and the expert kind of took it upon himself went through the questions of the attorney to suggest that the guy did not have that intent. He was constantly kind of fighting the facts and saying, well, no, he really didn't intend to threaten her. It wasn't serious. It was just hyperbole. I wouldn't. But the guy had already pled guilty. He'd already admitted, to having the intent to make a threat. And so I just was able to get up there and have fun with this expert. So I just went through and said, I pointed that out, of course. I said, well, you're aware, that this, that he's admitted that he had threatened. Well, and then I was just able to go through one by one the threats. And like I said, they were just so bad. So when you said you were going to kick her effing ass, he was going to kick her effing ass. That wasn't a threat to intent, and then a threat to physical harm. Well, no, it's just sort of the way, people talk sometimes. It's just an expression. And when he said he was going to bomb her house, that wasn't threatening physical. No, he was just going to bomb it with mail and not really physically bomb. And so when he said he was going to kill her, that was just, well, it just And so I was able to just run through my whole case in front of the judge. Had just ridiculed this expert because he was just trying. He went too far. He was going too far. They asked him one question too many. Did he intend to, threaten harm? And he said, insisting no, he didn't. So the judge ended up throwing the book at this guy. It was the Judge Marshall. She was one of the nicest judges in the courthouse, but she ended up giving him the guidelines maximum in this case, and I think it was small part due to the fact that they tried to basically unwind the plea agreement at the time of the sentencing. So his expert and his defense was not accepting responsibility for the offense at the time of the sentencing, and so she let him have it.
Hey James, it's been a pleasure having you on. Thank you.
Thank you, Steve. It's been a pleasure.
Can you tell our listeners the best way to get a hold of you?
Through your law firm, Steve. Yes, which you can find at eaglawgroup.com. And my email is james@eaglawgroup.com.
Thank you very much, Becky.
Thank you.